Any mention? May it please your lordship. Your lordship, I beg to make a mention of item number 4, your lordship. I humbly pray your lordship kindly this matter may be listed after 3 weeks, your lordship. Item number 4, your lordship. 3 weeks. I'm praying for 3 weeks, your lordship.
Why are you asking for 3 weeks?
Your lordship, we need some more time to prepare in this matter, your lordship.
2020 matter. How long you need for preparing?
Your lordship, if not 3 weeks, then kindly 2 weeks may be given, your lordship.
What is the matter about?
This is a Nokmadship dispute, your lordship.
You're having no objection?
No objection, your lordship.
Just wait for the learned counsel of the petitioner. Comma not objected to by the learned counsel that came for the respondents. List this matter after 3 weeks.
Highly oblige, your lordship.
Oblige, your lordship.
Please, your lordship. Lordship, I beg to make a mention of item 3. Item 3, your lordship.
For how long?
3 weeks, your lordship. 3 weeks.
3 weeks. This also same order. Yes.
Lordship, similar prayer on item 8.
Item 8, who is the other side?
Union, your lordship.
Dr. Mojika.
No objection, your lordship.
Same order. Yes. Yes.
Highly obliged, your lordship.
Your lordship, I beg to mention item number 10. Kindly let this matter come after 2 weeks, your lordship. No objection, your lordship.
Let's wait for on behalf of the petitioner. This is matter after 2 weeks. Yes.
Highly obliged.
May it please, your lordship. Lordship, I beg to make a mention of item number 9, my lord. I pray if the matter may be taken up after 2 weeks.
My lord, I am for the petitioner.
Yes, Mr. Hengresha.
Let it EHE. Oh, is a quite pending matter, man. If lordship give a short date, subject to lordship convenience.
The service matter,
Service matter, promotion, denial of promotion.
not that urgent.
My lord, it's quite.
How long?
2 weeks, my lord.
Mr. India, learned State Council. This is matter after 2 weeks.
What is
Deeply obliged.
obliged?
Lordship, a similar prayer for item number 11, my lord. On behalf of Learned Advocate General, my lord. My lord, I pray if the matter can be fixed on the 25th or 26th, my lord, he will be here physically, subject to my lord's convenience.
What is the controversy involved here in this thing?
Lordship, in this matter, what has happened, the District Council has 3 check gates under the regulation 1986. Now what has happened, the state government has issued one letter directing us to close those gates because it's been set up along the national highway. So we have challenged those letters and this court has granted us stay and we are running the gates.
Do you have any authority to set up a check gate on the highway?
That has been settled by this honorable court, Lordship. Your Lordship is also had appeared in one of those matters. Mine is Maulat.
So can this matter be taken up by this court?
We'll have to examine, Lordship. But,
so right now you have no objection?
no objection for the adjournment.
Okay. Let's speak for on behalf of the state respondents.
Lordship.
This is matter after 2 weeks. Yes.
Lordship, if 25th and 6th is, if it's convenient to my lord, 25th, because Advocate General, he'll be here physically, my lord. He wants to.
We do not know. Advocate General is supposed to be here always. Why?
Lordship.
He is not outside, isn't it? We'll have it after 2 weeks.
Deeply obliged.
May it please, your lordship.
Yes.
Lordship, I beg to make a mention of item 13 on behalf of Legal Aid Counsel R. Datta.
Yes.
Lordship, I'm praying this matter may come up after a week's time.
For the state? No objection.
No, sir.
Spread for by so and so on behalf of so and so. List this matter after 2 weeks.
Lordship, highly obliged, Lordship.
Deeply obliged.
Item number 1.
LCR.
Please, Your Lordship. Lordship,
Yes.
I pray for accommodation in this matter, Your Lordship.
Why? Why?
The learned DSGI is on legs, Your Lordship.
Last time also, you were accommodated. Huh? What is this matter, Mr.
My lord, this is with regards to the ACP and MSCP.
You have been deprived of the benefit of MSCP.
ACP and MSCP. Basically, it is the I'm asking from the initial rank. Initial.
So, what about? Let's say as per today. Land respondent and not objected by the lauded counsel for the petition, and this is met after
2 weeks, Your Lordship.
yes.
Lordship, 5 and 7 are connected, Your Lordship. 5 and 7, Your Lordship.
Both counsel same
Connect.
order, same order.
Oblige, Your Lordship.
Item number 6.
Please, Your Lordship.
Yes.
Lordship, here the petitioner this matter has become infructuous, Your Lordship, since the petitioner is no longer holding her post as an assistant teacher. This matter can be closed off, Your Lordship.
So you will withdraw it.
Yes, Lordship.
Okay. Mr. Soitzer, London Council appearing for the petitioner on instruction submits that the petitioner does not want to press this application and prays for withdrawals. Well, yes, in view of the submission, this matter stands dismissed or withdrawn. This matter is dismissed, not withdrawn. Yes.
Obliged. I oblige, Lordship.
Item number 12.
You just correct it. If I say something wrong here, grammatically, you just correct it. Okay? Yes.
May I be Lordship?
Yes.
Matter relates to a disability pension, my lord.
Lordship, I humbly pray this matter may be taken at the end of the board, Your Lordship.
And with the board is one difficult proposition. This court has to sit again in a division bench. So we do not know what happens and all. It's a difficulty, you see.
Conducting counsel is currently
If
on
matter,
legs, Your
if
Lordship.
3-4 courts are functioning at a time, then you must be prepared to handle it. Very difficult. That is a matter which was heard through
Yes,
VC of
yes,
the
my lord.
last
Yes, my
occasion.
lord.
Disabled.
Disabled, my lord. During the training period, my lord.
Yes. So, what is to be done?
I pray the matter may be taken after 2 weeks, Your Lordship.
Then,
When you are expected here back again, Mr. Singh?
my lord, it will depend upon today's hearing, my lord.
Today's hearing, so we do not know if Dr. Mojika is not there.
No,
We
no,
cannot
in
take
D-
it right
in
now.
DB, my lord.
If you want, we can keep
We
it
have
for the
to-
end of the board. But then when this court will come back, we'll do. That is the.
Then after 2 weeks, my lord.
You have any difficulty, you just inform them so that they need not come from outside.
Lordship.
That is one thing. At least if you do it, that is one way better. You see. Yes, on the request of the Learned Council, on the request made on Dr. Mojika, knowledge DSJ appearing for the respondents. This is matter of topics. Yes.
My lord.
Highly obliged, Your Lordship.
Item number 14.
Yes, we were struck somewhere probably. Was it?
No, my lord, it was concluded and your lordship was pleased to reserve the judgment. Thereafter, I have been informed that some clarification is required.
Some clarification. We did not clarify what is the point of to be clarified.
That was not. On the last occasion, one thing your lordship wanted to know that in the MB Act there is no whether 192 is non-cognizable or bailable. It is there in the CRPC, your lordship, in
That
respect
is
of
if you take the punishment thing. But then
for other offences, your lordship.
I don't think that part is disputed.
Not disputed. That's why, just for the reference purpose, my lord. It is in respect of classification of offences.
Now, just say supposing
My lord.
if a complaint is lodged, making allegation which comes to be registered under various section of law, including non-cognizable and cognizable. Now, as per the provision of CRPC, this will be taken as and then police will investigate the matter. Now, after investigation, if police finds out, charge, or they find out there is a case only under non-cognizable section of law, can they file a charge sheet?
That's why, my lord. In the case of that airport authority case, your lordship, Honorable Apex Court came to the conclusion that police can investigate because cognizable offence was also there. If it discloses non-cognizable offence, in that case,
that is where you say that then they'll have to, you see, instead of filing a charge sheet,
my lord, this is
you see,
special.
they can direct the party concerned to file a complaint or something like that.
My lord, because this is MB Act, special act, and there is a provision of, my lord, proper officer and proper officer.
No, the thing is that if you go by CRPC,
My lord.
the law bars investigation into a non-cognizable offence without the permission of the court.
True.
Now, if there is a bar of investigation, now the judgment which of the Apex Court which you have referred to, wherein it has been said that no charge sheet can be filed, but then probably the matter can be, you see, like, or the complaint matter can be
Referred to
the department, because that was involving the department. Now, what happens to an individual? You see, matter to that can be referred to a department when department is involved. Now, when the complainant is individual, then what happens? The police will direct the individual to file a complaint.
I don't think, my lord. In that case, as your lordship knows, my lord, one is complaint case, another is, my lord, FIR case. In complaint case, like NDPS, complaint case has been lodged by the authorities, my lord, because that is complaint case. In case of individual, my lord, is something, I'm not saying that they can report to the court also, but since in the present case, there is a special provision under MB Act and power has been given to the authorities to take action, and if it discloses only non-cognizable offence, in that case, my lord, as per charge sheet, in fact, in my submission, my lord, no cognizable offence also are made out, because 192 are not attached so far as the petitioner before your lordship is concerned, because the ingredients of 192 are not there. Number one. Number two, my lord, I am not the authority who has changed number plate. It is the transport department and, my lord, that MTO, your lordship, and the number which has been used, it is allotted to DGP. It is not that it is allotted to somebody else.
Now, that is what we have noticed on the other day while Mr. Shulai was reading the charge sheet.
The charge sheet also, my lord, they have.
That is what, you see, number was allotted. But then there was a direction, probably by the transport authority, asking you not to use MO02 number.
That thereafter it was not used.
Lordship, kindly come to the additional affidavit. Your Lordship, kindly come at page 15 at para 5 of that said report submitted by the investigating officer.
But then, see, hearing otherwise, Mr. Shulai, you see, it was probably completed, but then that was the issue, you see.
Yes.
What happens when investigation makes out only a case of non-cognizable offence?
In that
now, what Mr. Goyal says, basing on that Apex Court judgment, that is probably okay, all right, for a department it's okay. But then, what is the law? If when this investigation is barred, then how can this outcome of investigation be used for some certain things? What you are trying to point out, Mr. Sule? Page?
Lordship, in fact, Kindly come to page 15, Your Lordship.
Of the additional affidavit.
Lordship, yes. Investigation reveal, Lordship, whether Lordship is with me.
Yes.
Revealed that on joining of so and so, he intended to use the opposite Kia Carnival Lime limousine vehicle according to the government of Meghalaya, accorded and has conveyed its approval for usage of the said vehicle at the rate of so and so per day and night of so and so per night, with the condition that the officer shall use the private vehicle bearing registration number so and so under Meghalaya registration, not any other MLO2 registered vehicle.
That is all right. Now, next line says the investigation reveals that the side vehicle was
in use with the registration number so and so in violation of government approval. It is revealed that the registration number.
Now, will it attract any offence under 192?
Lordship,
192 speaks about a vehicle which is not registered.
Lordship, yes. It's like
Now,
this.
one thing is that undisputed this order, this number was allotted to DGP.
No, Your Lordship, the private vehicle is allowed to be used under Meghalaya registration, under any Meghalaya registration.
So, what do you mean by Meghalaya registration then?
Meghalaya registration, Lordship, it can be.
No, but then was it allotted? Any number, any registration was allowed? Number was allotted.
This wording also is very confusing, Your Lordship, under Meghalaya registration, because MLO2 also is Meghalaya registration, MLO5 also
And
is
not any
Meghalaya
ML02 registered.
and not any MLO2 registered vehicle. I know under what.
So that is perhaps basically this court other day took notice of that.
Lordship, if going by section 192, Your Lordship, this is only a finable section, Your Lordship. 192 is a finable section only.
No, that is all right.
It's not
But
a
even
penal
then,
penal section.
You see, it is not a problem. You see, paying fine is not a problem. Maybe
Lordship,
he
yes.
can give that amount as donation, but then it should not, no blemish should be attached to it. That is the main thing.
Lordship,
There should not be any stigma.
Lordship can make that observation and close the matter, Your Lordship. After all, he is our officer, Your Lordship.
Any other number was allotted apart from that ML02 number? No.
ML02001, it was allotted to DGP.
Apart from that,
No, madam, not me.
there was no other.
No other.
Even if you try to interpret, say that Meghalaya registration, what Mr. Sulai is very fair that way. You see,
Very
he says that
confusing,
there is.
Because MLO2 is also Meghalaya registration. MLO5 also is Meghalaya registration. MLO11 also is Meghalaya registration. I don't understand. The matter may be closed, Lordship.
But I mean, can you say that we have made concession or will be proper for you?
I'll not.
Anyway, then we'll pass on order.
Lordship.
Sorry, Mr. Gold, you have to come again.
My
for
lord,
these
it's
things,
pleasure,
but then
ma'am.
the question was that cognizable, non-cognizable part.
That
Now-
classification is there. And my lord, that
No, that is okay. He is not disputing.
my lord,
Now here also it's a case. Initially it was registered under various section of cognizable offences. Okay. So matter of investigation, but then the end result is non-cognizable. Now the question is that what happens to the outcome of investigation in such a case?
That Kerala judgment, Your Lordship, which I handed also.
they can investigate both the, my lord, if
Then-
it discloses both.
Then in that case, Your Lordship,
But filing of charge sheet, my lord, in my humble submission-
the charge sheet submitted by the police will be
Is it
treated
not-
as a complaint,
Is
Your
it,
Lordship.
is it not that while during the course of investigation, the police find that there is only involvement of a non-cognizable offence, is it not required upon that officer to obtain permission first and then to proceed?
my lord. As per CRP,
Probably that is the law. Yes.
that is,
Lordship,
See, 155 something, isn't it?
my lord, absolutely.
Lordship, that Kerala judgment which I have handed.
No,
also,
but then
that will speak-
this provision of law clarifies it. See, and then probably so far as this court understands, of course, subject to subject to correction. Maybe you see this, if in case that there is the outcome is something like the non-communal offence, then duty of the investigating officer first to obtain permission, and otherwise he should not proceed.
Lordship, the Kerala judgment is there, Your Lordship. I have handed over to Lordship. That is the
We'll just check it.
judgment of the Kerala High Court in 2016, Your Lordship.
Section 155, subsection 2.
Yes, exactly. Yes, that is good enough. See, Mr. Sulai.
If Lordship kindly have that Kerala judgment. There is a Kerala judgment, Your Lordship, that is the case of Sumesh versus State of Kerala.
Yes. Para.
If Lordship kindly come to Lordship para 9, that is the definition. That is a definition, Your Lordship. Then Lordship.
Para 10, para 15.
Lordship, then kindly come to para 14, Your Lordship.
Yes.
Applying the ratio of Sharat Chandra Sahu case, supra the fact reported to the police disclose both cognizable and non-cognizable offences, the police would be acting within the scope of its authority in investigating both offences as the legal fiction enacted in subsection 4 provide that even a non-cognizable shall in that situation be treated as cognizable.
That is okay. That is so far as it is.
Since the law is settled in the fact of the case, though the magistrate forward a complaint involving offence cognizable and non-cognizable in nature to the police, and the police filed a report finding that was committed, the magistrate is legally empowered to proceed with the trial. If so, content is. Well, this issue is, in my humble assumption, need not be addressed because it
Anyway, if not
in the report is very clear, Your Lordship, that he can use any Meghalaya number, Your Lordship.
that should be good enough to close.
So, Lordship,
In such a case, very long order may not be needed.
Yes, Your Lordship. Since the report reveals that yes, he can use any Meghalaya number, so I don't think it's.
We'll pass order.
My
Lordship. Oblige, Your Lordship.
deeply obliged.
Item number 15.
You sent it to my.
May please, Your Lordship. Lordship, the petitioner is before the Honorable Court for quashing of one FIR file against the petitioner, Your Lordship, whereby the petitioner met with an accident on 19/12/2022 while he was on his way back to his home, and he was riding a scooty bearing registration number ML05X7119, and on reaching near military hospital he met with an accident with the car which was driven by the respondent number 3, who was the private respondent in the instant case, Your Lordship. Your Lordship, what has happened was that initially after the accident, Your Lordship, the petitioner sustained severe injuries and the petitioner was hospitalized. During the course of his treatment, Your Lordship, the respondent number 3 and the petitioner parents, they amicably settled the matter, saying that the same will not be reported to any police station, the FIR will not be filed, or any counterclaim or claim will not be filed against each other. But during the pendency of the same, Your Lordship, the respondent number 3, fearing that the petitioner might succumb to the injuries that he sustained during the accident.
Who succumbed to the injuries?
Fearing that the petitioner will die because of the injuries that he succumbed during at the time of the accident, the respondent number 3 filed an FIR on 25/12/2022 before the Sadar police station, Your
After
Lordship.
6 days.
Yes, Your Lordship. The FIR was registered, Your Lordship.
They'll have to see it.
The FIR was registered on 25/12/2023, Lordship, under the provisions of IPC, that is section 279 and 337 were attracted against the accused person in the case, the petitioner.
Rash and negligent right.
Yes, Your Lordship. In this case, Your Lordship, after filing of the FIR, the petitioner was discharged from the hospital, and then, Your Lordship, the petitioner and respondent number 3, they met together and they discussed that there are, since as such there are no claims and counterclaim between both the parties, and whatever the car of the respondent number 3 was damaged, the petitioner, he paid to the expenses whatever he incurred for repairing of those as well. Then after that, Your Lordship, both the parties, Your Lordship, executed a compromise deed saying that the matter will be closed. After execution of the compromise deed, Your Lordship, which is annexure 3, Your Lordship,
This
Page
non-compoundable.
25.
This non-compoundable offence.
Yes, Your Lordship. 279 is non-compoundable, Your Lordship. 337 is compoundable. So just because the section 279 is attracted, Your Lordship, the petitioner is before
You are referring to page?
page 25, Lordship.
Yes.
So, Your Lordship, 22nd September 2024, both the parties, they settled the dispute and executed this compromise deed, Your Lordship. Then, Lordship, both the parties approached the investigating officer of the instant case also, Lordship. But the Lordship, since the section that is attracted, one of the section that is 279, which is attracted against the petitioner in the instant case, being a non-compoundable offence, Lordship, the petitioner is before the Honorable Court for quashing the instant FIR, Lordship. And in the meantime, Your Lordship, after filing of the FIR also, Lordship, the petitioner was enrolled in BSF right now, and he's serving in BSF. So my humble submission is that, Your Lordship, the FIR may be closed, Your Lordship. And moreover, one of Your Lordship, the coordinate bench of the Honorable Court has also passed in similar circumstances.
Is it?
Yes.
79.
Yes.
Yes, Mr. Kharmi.
Yes, Lordship, in this matter, Lordship, this private respondent, he's representing the private respondent, Lordship.
What about the state?
The state, Lordship, we have registered a case, and because they have compromised, Lordship, so
You
if
are not much against.
if they have
So
no
you do not-
objection, then
You do not have any serious objection, is
yes, if they she doesn't have any objection.
it? Okay. Just right. Heard Mr. Joshi. Learned counsel appearing for the petitioner, and also Mr. H. Kharmi appearing for the respondent number, state respondent number,
1 and 2.
and your name, please. Yeah, Buam. Learned counsel appearing for the respondent number 3. Paragraph. The fact of the case is that just a brief fact of the case is that on 19/12/2022, the petitioner on his way back home Acha, what is it? Twenty-two. When the petitioner was back home and was riding, yes, a two-wheeler within bracket to ride scooty, bearing registration number ML05X7119, met with an accident with the vehicle. What vehicle that was?
Tata Nexon.
Within bracket, just say Tata. So, is there a registration number?
Yes.
Where do we get it? It is there mentioned anywhere?
In the FIR.
At page?
Page 18.
ML05B8481. Tata Nexon, isn't it?
Yes.
You can see it at page 22. With the vehicle number so and so. Near military hospital, Dilbong. Stop. You had to be treated as indoor patient.
Yes.
Yes. The petitioner had sustained injuries and had to be rushed to a nearby hospital for treatment. And where he was treated as an indoor patient. Stop. You say although, just say although, immediately after the accident, there was no filing of FIR by any of the parties involved. Come on. The respondent number 3, fearing respondent number 3, in order to avoid any future consequence resulting from the said accident, filed an FIR dated. What is the date?
25/12/2022, Lordship.
Where it is reflected? 25/12/2022.
Page 18.
Before the officer in charge, Shodar Traffic Branch, East Kasil, Shillong, which was registered as what is the case number?
Southern PS case.
case number.
Where is that?
2512 of 2022.
Where it is? Where
Paragraph
is
2.
Paragraph 2 of the
paragraph 2 of your petition?
Yes.
Yes. Just get it from there. Okay. And the matter was investigated into. Stop. After the completion of the investigation, the charge sheet stroke final report was forwarded by the police.
Lordship, the charge sheet is not yet filed in the instant case, Your Lordship.
It was ready only for filing of the
Yes, sir.
but they have compromised.
It's all right. It is matter of investigation. Stop. It is submitted that no charge sheet stroke final report has been filed. It is just say it is submitted that filing of the charge sheet stroke final report in the matter is still awaited. Stop. The petitioner has approached this court seeking quashing of the said Sadr PS case number 285 in bracket 12 of 2022 on the basis of the compromise entered into between him and the respondent number 3, comma, who is the complainant. In the who is the complainant? Who is the complainant? Stop. What you said? Just like me, petitioner is stop. Paragraph. Learned counsel for the petitioner submitted that immediately after the accident, the petitioner and the respondent number 3 had settled the matter and the filing of the FIR by the respondent number 3 is only a preventive step, so that in order to avoid, in order to avoid any future consequences arising out of this matter. Stop. He submits that even after the filing of the FIR, during the course of the investigation, the parties have entered into a settlement. What is that agreement?
Annexure 3, Lordship, page 25.
Page
25. 25, 26 and 27.
What is it? But the point what is there? The settlement stroke is just a compromise in the matter. That we do not have to write this. What is it? Says to compromise stroke agreement. dated 22nd September 2024. Whereby both the parties of their own accord voluntarily decided to amicably settle the matter and not to pursue any illegal proceeding before any court of law. Step. Give a paragraph. MS Buam, learned counsel appearing for the resolution number 3, supported this submission advanced on behalf of the petitioner, and has also acknowledged the fact that the parties have amicably settled the matter. Stop. The next paragraph is Mr. Kharmi, Lord and additional PP, appearing for the state submits that since the parties have settled the matter, the state would not like to raise any objection to the against the settlement. Stop. Paragraph. See, upon consideration of submissions made by the rival parties, made by the parties, not the rival parties, made by the parties, and on consideration of materials on record, it appears that the petitioner in the respondent number 2 indeed have entered into a compromise stroke settlement voluntary of their own will to compromise the matter, and not to pursue any legal proceeding against each other. Stop. It is also clear that apart from the petitioner and the respondent number 3, no other individual had received any kind of injury from the accident which occurred on 19/12/2022. and the proceeding and the incident concerns only the petition and the respondent of a thing without having any bearing concerning the general public. Stop. What are those decisions that Gyan Singh's judgment and all? Achha. Any, forget it. The learned counsel for the petitioner has placed before this court a copy of judgment and order dated. What is the date? 21/3/2023. Just see, date part is gone. You should be sure. See, please verify this thing. Anyway, 21/3/2023. Wherein the wherein a coordinate bench of this court had granted the wherein has had quashed the proceeding in a similar in a matter which is identical to the present case. Stop. A perusal of the said order reveals that that this High Court has the High Court on the basis of the various decisions rendered by the apex suit in this regard had allowed the had accepted the settlement in a similar situation and allowed the proceeding therein allowed the allowed the proceeding therein next paragraph. Since the present proceeding is identical, since the present case, not proceeding, present case is identical to the fact and circumstances involved in criminal petition number 17 of 2023. Come on. This court, in consideration of the submission made on behalf of the parties, deems it appropriate to allow the prayer made by the petitioner. Stop. Resultantly, the FIR dated 25/12/2022 and the proceedings of this, what is it? Resultantly, the FIR dated 25/2022. Okay, and the proceedings of Southern PS case number 285 within bracket 12/2022 under section 279/337 IPC stand post. Stop. This revision. This criminal petition is allowed.
Deeply obliged.
So, yes. There may be some correction here. There.
Yes, Your Lordship.